Afternoon, everyone, and welcome to this seminar given by Kingsley Abbott, the next director of the Institute of Commonwealth Studies. I'm Professor Sue Onslow, the outgoing director of the ICWS, and I want to stress how delighted we are that Kingsley is joining the Institute and the School of Advanced Study, and he will be in post in April. Kingsley comes to the ICWS from the International Commission of Jurists, where he's been director of global accountability and international justice for the past 9 years. He is going to be talking today on trends in international criminal law, drawing on his extensive legal experience in advocacy, in investigative prosecutions and defense work over the past 2 decades. So Kingsley, welcome.
Great, thank you very much, Sue, and it's a real pleasure to be here and to join you all to talk about some of the trends that we're witnessing at the moment in international justice, with a reference, of course, to the Commonwealth. You know, I'm very much looking forward to joining the Institute as the new director in April, and I'm hoping then I'll have an opportunity to meet many of you. A few words about my background. Sue has already, you know, set it out in brief, but I started my career as a criminal barrister in New Zealand, working with some leading King's councils as a courtroom lawyer. After that, I worked for the United Nations in Cambodia at the Khmer Rouge Tribunal for about 5 years in 2 different stints, and in The Hague at the Special Tribunal for Lebanon. And as Sue said, for the past 9 years, I've been based out of Thailand, where I've been working as the Director of Global Accountability and International Justice at the International Commission of Jurists. And one of the great pleasures of mine, and I think one of the ways it's helped me come at this issue, is by being based out in the global south. I was able to spend a lot of time with affected communities and survivor groups and victim representatives who have the most important voice in the evolution of international justice. Since we have only an hour, this will just be really a short overview with a few selected observations that I've selected, but I hope they'll be of interest to this group. And it's not going to be a long and involved law lecture. I want to also leave some time for questions at the end. So the 5 trends in international justice that I've decided to talk about, some of which I find the most interesting, is firstly, the increasing use of universal jurisdiction around the world, which I'll describe in a little more detail in a minute. The second is the emergence of a new generation of UN body created accountability mechanisms. The third is the increasingly sophisticated role civil society is playing in international justice and the greater recognition of their importance. The fourth are some legal and strategic innovations we're seeing, including before the International Criminal Court, the International Court of Justice, and in other fora. And lastly, something that fascinates me as a former practicing criminal lawyer is the use of new technology to address the special challenges that investigations face in the digital age. But I thought I'd begin with a brief snapshot of where international justice is at more generally, to contextualize some of these trends, because I'm sure not all of you are glued to the news of developments in international justice on a daily basis. But I think the place I always begin is to say that under international law, it is states that bear the primary responsibility to combat impunity for crimes under international law at the national level. That's the way the system is supposed to work. And by crimes under international law, I'm talking about aggression, war crimes, crimes against humanity, genocide, slavery, torture, enforced disappearance, extrajudicial killings, those categories of crimes. And when violations like those take place, it is states that have the duty to carry out investigations and, where appropriate, prosecutions that meet international law and standards and provide remedies and reparations to victims. So international criminal justice usually only then enters the picture in situations where crimes under international law have taken place, but states are unwilling or unable to fulfill their obligations. And some reasons for that include that the state may be embroiled in conflict, or it could be in a post-conflict situation where there's a lack of political will, sometimes because the perpetrators are still in power, or a lack of capacity, say the lack of an independent and impartial judiciary which is able to deliver justice and remedies and reparations to victims in accordance with international law and standards. As many of you will know, international justice, as we know it today, sort of modern international justice, has made huge strides since the end of the Second World War. You'll remember that following the end of World War II, we witnessed the Nuremberg trials, the Tokyo trials, other related trials. And while those trials that took place continue to have their critics as examples of victor's justice, or as famously said, high politics masking as law, they did usher in the modern era of international criminal justice, serving as both a model and an inspiration for future developments and advancing the substance of international criminal law. Even judgments that come out of the International Criminal Court today, for example, will refer back to the precedent of the Nuremberg trials and the Tokyo trials and so on. Then the next big movement, if you like, or the next big advance took place nearly 50 years later in the 1990s, where there was a really unique moment of global cooperation and optimism following the end of the Cold War. And first we saw two ad hoc or temporary tribunals created by the UN. The first was the International Criminal Tribunal for the former Yugoslavia, which we all colloquially know as the ICTY. And the other was the International Criminal Tribunal for Rwanda, ICTR, to address serious human rights violations that took place in those two situations. And then shortly thereafter, in 1998, the International Criminal Court's founding treaty, the Rome Statute, was adopted. And that entered into force in July 2002. Of course, the International Criminal Court is still around today. It's significant because it is the first and only permanent treaty-based international criminal court. And it only looks at two crimes, or it has jurisdiction over two crimes, genocide and aggression, and two categories of crimes, war crimes and crimes against humanity. It's also said to be a court of last resort, meaning that it's not meant to take the front pole position whenever Rome Statute crimes are committed. It is meant to complement national processes and only step in as a last resort where the states concerned with that situation are unable to carry out fair or effective investigations and fair trials themselves. So it's a court of last resort. The goal that all of us working in international justice have is universal ratification of the Rome Statute, meaning that every state in the world signs up to the Rome Statute and becomes a member of the International Criminal Court system. And encouragingly, 123 states have ratified or acceded to the Rome Statute, which is, the vast majority of states. But several key states are not members, including, I think, most notably, some of the most powerful states in the world. The United States is not a member, China is not a member, Russia is not a member, and those are all significant, not only because of their populations and their geopolitical power, but they also hold permanent seats on the UN Security Council and therefore hold veto power when resolutions are presented before the Security Council. And several Commonwealth states are also not members of the Rome Statute system. In fact, none of the top 5 most populous countries in the world, making up about 45% of the total world population, are members. China, India, USA, Indonesia, Pakistan are not members. And of the 56 Commonwealth states, based on a bit of a calculation I did this morning, 37 of the 56 are state parties. 19 of them, or around 33% or a third, are not yet parties to the Rome Statute. And that is something that has to change. So that's something I want us to make a note of when talking about the Commonwealth. There needs to be more work done to bring some of those 19 states into the Rome Statute system. And speaking about the Commonwealth, I note encouragingly on this that in 2011, the Commonwealth Secretary General signed a memorandum of understanding with the International Criminal Court to strengthen and develop cooperation between the organizations to support states implementing international criminal law. So that's something I will be looking at after I take up my post, just to see how that memorandum of understanding has been interpreted and how it's progressing. But that MOU has been in place since 2011. And over the years, other ad hoc tribunals or temporary tribunals and courts, in addition to the ICTR and the ICTY, have been created as well, of course, for Sierra Leone, East Timor, and where I worked in Lebanon and or for Lebanon and Cambodia, among others. Now, something I always like to note at this juncture is that while we often hear in the media and from victims and from other stakeholders that international justice deserves criticism, and I agree with that in many cases, I think it's important to recall that it's something of a marvel that it exists at all. It's something quite incredible that we have a permanent international criminal court with so many states members of it. You know, an interesting question to ask is whether we think a permanent international criminal court with the powers of the ICC could be created today in the current global climate. And I think that not many people think that something would be possible. So in many respects, whilst the global international justice architecture still is, still needs a lot of work, still has a lot of challenges, is still failing many victims, it's still a project or a movement that I wouldn't say is quite in its infancy, but perhaps in its early teenage years. And that's why many of those working in international justice are still constantly looking for progressive and innovative ways for it to provide access to justice to victims around the world, particularly those who are most vulnerable. So it's an ongoing effort. It's not yet set in stone. And although I think that I described those two accountability moments after the Second World War in the 90s, and I don't think the current global climate would be sufficient to create the ICC today, perhaps. It is true that the tragic war in Ukraine at the moment has created another accountability moment, I think of a much smaller magnitude, but a moment nonetheless, which I'll talk about a little more later. So then turning to where we are in 2023, despite all these developments, and there have been many, the challenge of impunity or the scourge of impunity for crimes under international law remains a huge challenge all over the world. So despite the fact we have this international justice architecture in place, we still see impunity, in other words, people getting away with perpetrating crimes under international law all over the world, from Myanmar to Syria, Venezuela to Libya, and now on many people's minds in Ukraine, and also in many Commonwealth states. Impunity is the rule rather than the exception. The second point I'd like to emphasize again is that in 2023, despite those challenges in seeking accountability, international justice, whilst remaining imperfect, is still evolving in the face of many of these criticisms. And I'll name just three of the general criticisms that international justice receives. And I think all of them have their validity in certain contexts. The first, which is certainly an enormous challenge, which is barely in dispute, is that international justice is sometimes perceived to be too selective, too biased, that the political will for accountability only exists for some victims or some category of victims and not others. And for example, during the early years of the International Criminal Court, it was often criticized for focusing too much on African states and not on other situations around the world. And last year, 43 states referred the Russia-Ukraine situation to the International Criminal Court, while in many other situations there has been silence or even opposition to the work of the International Criminal Court. Most appallingly, during the last administration of the United States, it went so far as to even issue sanctions imposed on the prosecutor of the International Criminal Court for the work she was doing and the work of her colleagues, apparently linked to some of the work it was doing in relation to Afghanistan and Palestine. At the same time, millions of euros of voluntary funds, technical support have flooded in to the International Criminal Court for its investigation into the Ukraine. And, you know, that is, of course, to be welcomed. We're witnessing an appalling war unfolding in real time in Europe with thousands of victims. But at the same time, international justice needs to evolve in a way that is not selective, that is equitable and fair for all victims around the world. And I read with interest a statement issued in July last year at a high-level conference on accountability in Ukraine, where two coalitions of Ukrainian civil society organizations stressed the need to avoid any perception of a two-tier global accountability system in which some victims are more deserving than others. And that was, I think, a very powerful message to come from Ukrainian civil society organizations. And this sense of a two-tiered system is something that, you know, many victims around the world have complained to me about. Most recently, friends of mine from Myanmar, and obviously living and working in Thailand, I've worked extensively on Myanmar over the last several years, and they felt that they were getting as much as they could from the international system for the appalling violations that took place in Myanmar and are still taking place in Myanmar, until they saw the global support for accountability in Ukraine. And they said, you know, why are we not getting this kind of support? Why are the investigations that are taking place not receiving the same kind of budget and financial aid that situation is receiving? Has our own suffering now been eclipsed by Ukraine? Now, no one is suggesting for a moment that any of these conflicts are worse than others, or that some victims have suffered more than others. It's just about the ensuring that there is sort of equitable, fair, and a logical progression to the way international justice develops, so that certain groups of victims are not left behind. The situation in Ukraine from an international justice perspective has, however, revealed some of what is possible when states really put their efforts behind accountability. And there is now renewed attention on the idea of accountability. What is the International Criminal Court? What's it doing? What are its strengths? What are its weaknesses? And there are new conversations now taking place around this apparent double standard. And that I think is, you know, welcome. The fact that these conversations are now taking place again is something that I think is very important. The second, you know, very common criticism is that international justice takes too long, it's too expensive, it's too ineffective, it's too weak. And people point to facts like, despite probably nearly, I think it's around $2 billion having spent at the International Criminal Court since its inception, and a budget for this year of around 170 million euros, there have only been 10 convictions. And in the last 20 years, it has not sustained the atrocity conviction of any heads of state or any state officials. And its proceedings take years. And this raises a very interesting question, which we won't go into today, is how do you measure success and value and money well spent in the sphere of international justice? Is it just based on number of trials, number of convictions, number of victims reached? But that's a conversation for another day. But it's much more complex than certainly simply looking at how much money is spent in one column and the number of convictions in the other. And all international criminal justice processes, from the ICC to the work I was doing in Cambodia, Lebanon, everywhere else, always runs into these conversations. The last, I think, certainly not the last criticism out there, but the last criticism I wanted to raise was really one that is quite close to my heart, given the work I've been doing with victims and survivor groups over the last several years, is a sense sometimes that international justice is too remote. It's too distant from victims. Many of these efforts, including those of the International Criminal Court, are taking place too far away from the victims and the affected communities. And it's not just that the proceedings are taking place in the Netherlands and the victims, say, are in Myanmar and Bangladesh. It's also that too little information is being provided to them about the ongoing processes, their rights, how they might engage with the process, what the International Criminal Court can do and can't do, how are things proceeding. And, I acknowledge at the outset that, it's a tremendous challenge and there's no easy answers to it. And it's not always possible to hold proceedings in places where violations have taken place. In Cambodia, they held the Khmer Rouge Tribunal in the country, but that wasn't without its challenges either, because of the very weak rule of law situation in the country that existed and still exists, and the way in which that weak rule of law situation led to allegations of the Cambodian government's political interference in what was meant to be an independent process. But there's a lot more work that can be done on what we call outreach, greater engagement in the affected regions, regional offices, partnering with civil society to have more events explaining the processes, better translation into various languages, news of the processes and so on. Otherwise you enter into a very strange situation, which is that you have, rooms full of people in a place like the Netherlands working away, seeking justice for, let's say, the Rohingya and other affected minorities in Myanmar. And then you have the Rohingya themselves and those other affected minorities not having a clue as to what's going on. And there's this tremendous disconnect. And that's something that I felt very acutely on the couple of occasions that I visited the Rohingya refugees and the refugee camps in Cox's Bazar and in Bangladesh, both shortly after when they were most recently victims of awful atrocities and pushed out into Bangladesh. And again, last year, despite some years passing, there was still so much work to be done for many of those to understand, what is the ICC? And then that raises questions of legitimacy. If there is then perhaps theoretically an arrest warrant issued, somebody put on trial, a conviction there in The Hague, what does it mean for the victims and affected communities? What was the point of that? If it's not having an effect in strengthening the rule of law in the country, providing remedies and reparations to those victims, acting as a deterrent. So against that backdrop, I think let's then just talk about some trends or developments in international justice. And I've selected, I think, what I would consider mostly positive trends. You'll probably be pleased to hear. And I think one overarching development is that we are no longer really talking about international justice being primarily the domain of the International Criminal Court and the ad hoc tribunals. And that was a little bit how it was when I started practicing international criminal law, say, I think 15 years ago. The sense was that international criminal justice or international justice was something to be delivered by UN body created tribunals and the ICC. But as the former US ambassador for war crimes, Stephen Rapp, somebody I work with quite closely, often says, we are now talking more about a sophisticated ecosystem of international justice, with many parts, many stakeholders, all interdependent, with a renewed focus on what can be delivered by national jurisdictions at the national level. And some experts even claim quite openly that they consider that the future of international justice is domestic. And that leads me into the first trend I wanted to talk about, which is the rise of universal jurisdiction and other extraterritorial jurisdiction, and prosecutions and investigations at the domestic level in national jurisdictions. Now, universal jurisdiction sounds awfully complex, but to put it simply, it's defined as a legal principle allowing or requiring a state to bring criminal proceedings in respect of certain crimes, irrespective of the location of the crime and the nationality of the perpetrator or the victim. In other words, universal jurisdiction is based on the idea that the global fight against impunity is borderless, that it doesn't matter if crimes against humanity were not committed inside my state. Crimes against humanity is of such concern to all of humanity, even though it wasn't committed in my state, and even though the victims were not nationals of my state and the perpetrators were not nationals of my state, I'm going to open up our state's justice sector, our judicial apparatus, to bring proceedings where we think that it is something worthwhile doing. And many states, since ratifying the Rome Statute of the International Criminal Court, have adopted laws criminalizing war crimes, genocide, crimes against humanity, for example. And many states have also, to varying degrees, because there's always slight differences in the domestic legislation, have enacted laws allowing for universal jurisdiction. And we're now seeing quite a number of prosecutions and investigations taking place, predominantly in Europe, under universal jurisdiction. But there is a real need for other states, including within the Commonwealth, to take up that challenge and to provide fora for there to be universal and other extraterritorial proceedings brought within those Commonwealth states, which is another note of this talk. According to an international NGO called Trial International, which does a lot of work on universal jurisdiction, universal jurisdiction cases are very much on the rise, with over 100 defendants, mostly living in Europe, being prosecuted for crimes back in places like Syria, Liberia, Iraq, Rwanda. And this development, which is very welcomed by most of the international community, has been really pushed for, and as a result of the important pressure that civil society groups around the world have brought, saying we need accountability, we're not getting it in some of the more traditional avenues, and so we need states to open up their doors for universal jurisdiction. And many European countries have now established specialized war crimes units, which are opening up complex structural investigations into country situations like Syria. And this has really allowed states to address some of the challenges of selectivity that I was talking about before, this two-tiered justice system, where certain categories of victims felt that all the avenues for justice to them were blocked. Universal jurisdiction is helping unblock some of those avenues, although it's still limited. And just to give you an example, in light of the inability of the UN Security Council to refer the situation of Syria to the International Criminal Court, the UN Security Council has the power to do that, but it was not referred because of politics at the level of the UN Security Council by those permanent states holding veto power. Investigations and prosecutions in third countries are really one of the only options for justice for Syrian victims and survivors. And one example that made the news quite significantly was a landmark first trial for state-sponsored torture in Syria against someone called Anwar R, which concluded last year in the German city of Koblenz, which is a powerful example of national judicial authorities acting based on strong domestic legislation. Another recent illustration is the conviction by a French court of a former Liberian rebel leader for crimes committed during the country's first civil war. And all these efforts at opening up doors for universal jurisdiction for crimes under international law to be prosecuted in states, irrespective of where those crimes took place or where the victims and perpetrators are from, has the support of the International Criminal Court. The prosecutor of the International Criminal Court, in his most recent report at the end of last year on the activities of the court, said it ultimately doesn't matter. It does not matter where crimes of atrocity are prosecuted, whether it's domestically or at the International Criminal Court. Indeed, domestic prosecutions are often preferable. Such prosecutions are owned by the state and its judicial system, and increase understanding of Rome Statute offences by the communities most directly affected. Of course, this is an evolving principle, and over the past decades, it's received some criticism based on its own perceived selectivity, perceived politicization, perceived Eurocentricity, and that many of the processes are being brought in European courts, and again, the detachment of justice from affected communities. And those prosecution teams or war crimes units carrying out these efforts in these different states, bringing universal jurisdiction cases, do need a lot of assistance. It's very challenging. As you can imagine, they are very remote from the situations where the crimes took place. You can imagine prosecutors sitting in Germany trying to understand the situation in Syria with all the attendant language and cultural and contextual challenges. Same with those French prosecutors looking at the situation in Liberia. They're not able to carry out investigations on the grounds themselves in most instances. And they need help building international criminal cases, which by definition are sometimes a lot more complex than national prosecutions. And this is where the next two developments I want to talk about come into play. The first is the new generation of UN body created accountability mechanisms. And the second is the rise of specialist NGOs and the more important or the more enhanced roles that civil society is playing in international justice. So the new generation of UN body created accountability mechanisms. Again, this sounds complicated, but I'll try and simplify it. Over many years, UN bodies like the Security Council, the General Assembly, the Human Rights Council have created fact-finding missions and commissions of inquiry in situations where violations have taken place. And often they are tasked with monitoring the situation, documenting the violations, focusing on state responsibility rather than individuals who may have committed crimes. And the result is usually a report which makes recommendations for legislative reform, judicial reform. This is the kind of report that's produced by these commissions and inquiries historically over many years. But in the last 10 to 15 years, there's been a real accountability trend. And it's been in a direct response, really, to some of the shortcomings that we're seeing in other parts of the world and inability of the UN Security Council to refer situations to the International Criminal Court. What's happened is that mechanisms are increasingly being created by these UN bodies, particularly the UN Human Rights Council in Geneva, which go much further than those traditional roles I described and are tasked with looking at serious human rights violations, violations of international humanitarian law, international criminal law, looking at, importantly, carrying out criminal investigations, preserving, consolidating, analyzing evidence, and holding it so that it can be used in future criminal proceedings, wherever they may take place, whether it's at the International Criminal Court or before some state exercising universal jurisdiction. So these commission inquiry and fact-finding missions are now being enhanced with respect to their mandates, where people are saying, well, look, we've got all these blockages elsewhere. Let's create a new mechanism, say for Syria, say for Myanmar, and that mechanism is going to essentially act as a prosecutor with an investigation team gathering evidence to a criminal trial standard that can be used sometime in the future when an accountability or an opportunity for a trial opens up. And this was a little controversial at the time because people said, well, the idea of throwing all of these resources at essentially a prosecutor without a court isn't full accountability. It's a halfway measure. And we need to see whether or not it works, whether or not it actually results in something other than just huge archives filled with evidence that nobody's using. And in fact, I think there are now about 12 of these mechanisms. And a big part of my work over the last 5 years has been to work on this issue. When should they be created? What should their mandates be? What sort of budget should they receive? What sort of challenges do they face, and how can that be addressed? And the concept, I think, to a large extent in the last couple of years has really been proven to be an effective one for the most part. And that's in large part because one of the prototypes, one of the first of these new generation mechanisms that was created, this one by the UN General Assembly, was what's called the IIIM, I think it's the Independent Impartial Investigative Mechanism for Syria. And this mandate is looking at collecting evidence of violations that took place in Syria, preserving that evidence, and making it available for possible accountability processes taking place around the world. And just last year in 2022, the IIIM, the mechanism for Syria, reported that it had received 72 requests for assistance, bringing the total of requests for assistance from 2018 to 2022 to 237. So those are 237 external requests for assistance from states, mostly requesting evidence that it might be holding. And those relate to apparently 192 different investigations or prosecutions being conducted across 15 different jurisdictions around the world. And so this has really shown that this movement to create these enhanced investigative bodies at the UN body level is really having an impact on the work of the International Criminal Court, but particularly countries around the world that might be thinking of exercising universal jurisdiction. And although the IIIM hasn't said it, it's strongly implied that they provided some of the evidence, for example, that was used by the prosecutors in Germany last year when they won that conviction against Anwar R in the Syrian case that I described previously. The third trend is the more sophisticated role that some civil society organizations are playing and the greater recognition of the importance of the work of civil society organizations. And so at the same time as we are seeing these new specialized mechanisms being created by UN bodies, a new category of sort of non-state actors, INGOs, international non-governmental organizations have emerged that specialize in gathering evidence, the documentation of crimes, the collection of testimonies, the location of suspects, and sharing that information also with the International Criminal Court and states willing to exercise universal jurisdiction. It has to be said, however, that many national NGOs within countries, nearly every country where violations have taken place, have been gathering evidence and documenting violations for decades. And they are the real experts in the local context and the local language. But here we are now seeing a shift from not just documenting those violations for use in human rights advocacy, but actually collecting evidence in a manner and in a form that can actually be used in criminal proceedings, which is a much higher standard. And some international NGOs are emerging with very specialized agendas. For example, some of them you may have heard of, like Witness, Bellingcat, which specializes in open source investigations, Eyewitness, and I think one of the most interesting ones is the Commission for International Justice and Accountability, Seizure, which not only helps support local civil society groups and local initiatives, but they also carry out their own investigations. And if I just take Seizure as one example, because this is a real development or a new trend in international criminal justice, this INGO Seizure has 130 specialist personnel working for it, many of whom are former officers of the International Criminal Court and all the international criminal tribunals that may have since closed down, they've moved to Seizure. And for an INGO, they're carrying out the same work. They're carrying out investigations, building national capacity to investigate, preserving and managing evidence, analyzing the evidence, building cases. But most importantly, once they've collected all of this evidence, they are then assisting justice sector actors. And again, mostly at the level of national jurisdictions who might be willing to bring criminal proceedings under universal jurisdiction. And I read that between April 2019 and March 2020, Seizure assisted 32 entities from 13 countries, including national law enforcement agencies. It's received 169 requests for assistance, provided information on 718 targets and 451 suspects. So this is where we're talking about this ecosystem. When I started out 15 years ago, people used to think most of the work had to be done by the International Criminal Court or one of these tribunals that was created for, say, Rwanda or Yugoslavia. But now we have all these other actors that are coming into the space, and one hopes acting as force multipliers, where the combined work of all these different groups and collecting, consolidating, preserving evidence and sharing it with the International Criminal Court and with national prosecution agencies is further closing the accountability gap and making the global fight against impunity a lot stronger. And again, this is also something that is being welcomed by the International Criminal Court. And I should say that Seizure also helped provide evidence in that same case, Anwar R, the case in Germany concerning Syria. So you can see here's a group of German prosecutors. It's going to be very difficult for them to gather evidence of what's happened in Syria, but they are being fed evidence and technical support not only from the IIIM, but also from Seizure, also from other groups that are all banding together to support those prosecution efforts. And the prosecutor of the International Criminal Court last year really, I think, pushed forward the acknowledgement of the important work that others are also playing, that the International Criminal Court can't do it all on its own. Last year, they launched a CSO initiative, civil society organization initiative. They've also published guidelines on the documentation of international crimes and human rights violations, saying that the fight against impunity is not solely the preserve of states or international organizations. It's a collective obligation that must benefit from the contribution of all of those who seek to advance the cause of justice. I'll just move on to the two other trends that I witnessed, because I want to leave a few minutes for questions. One is increasing innovation at the International Criminal Court and in other fora. And we're seeing this before the International Court of Justice as well, in national jurisdictions, and not just in the criminal or individual criminal responsibility sphere, but also in civil proceedings. And Myanmar, I think, provides a great case study. And I'll just be very brief, but in 2016 and 2017, when appalling violations took place in Rakhine State in the west of Myanmar against the Rohingya minority, hundreds of thousands were forced across the border into Bangladesh. Strong evidence of genocide, certainly crimes against humanity and war crimes. People like myself were asked, well, what is the prospect of justice for the Rohingya? And at the time, it looked very bleak. And that situation really highlighted the weaknesses and the gaps in the international justice architecture, because there were no credible investigations taking place in Myanmar. Myanmar had not ratified the Rome Statute, so there couldn't be an International Criminal Court investigation. We then were able to look to the UN Security Council, who could refer the situation to the ICC, even though Myanmar wasn't a member of the system. But because of politicization amongst the permanent members, there was no Security Council referral. No other investigations were taking place. And universal jurisdiction cases weren't really possible at that time because, none of them had been opened in any third countries, and certainly they didn't have the knowledge or the evidence to do it. But then suddenly, within a very short space of time, multiple accountability avenues were opened due to the tenacity of victims groups, civil society, and lawyers working to support them. The ICC found a way to get involved. They said, well, next door, interestingly, Bangladesh is a member of the Rome Statute system. And if the victims started their journey in Myanmar as victims of violations, and some of those violations carried over or continued into Bangladesh, and Bangladesh is a member of the Rome Statute system, then we can get involved. And so the ICC then started investigating crimes committed against the Rohingya, where part of the crime took place in Bangladesh, which was, a real innovation at the time, and quite, fascinating for us international lawyers to watch, because many of us, frankly, hadn't thought about it as a possibility. And when it was proposed, and we, the International Commission of Jurists, filed an amicus brief at the ICC saying they should do this, we weren't sure how successful that argument was going to be, and it was successful. The second thing that happened is that the Gambia brought a case before the International Court of Justice alleging Myanmar had violated the Genocide Convention. So now there's a whole proceeding before the International Court of Justice. Thirdly, the UN Human Rights Council created one of those mechanisms I was talking about, the IIMM, Independent Investigative Mechanism for Myanmar, which has been investigating and collecting evidence of violations in the country since 2011 and on an ongoing basis. Several universal jurisdiction cases have also been have also commenced, including one, the first one in Argentina, which you might say was very remote from Myanmar, but there is now a proceeding in Argentina concerning Myanmar. And I think, interestingly, also other litigation is being pursued, including against Facebook, where victims groups lawyered up in the UK and the USA brought proceedings against Facebook for failing to take adequate steps to combat hate speech on its platform in relation to those atrocities. And there are many other innovations we're seeing in the international justice space concerning civil litigation, sanctions, and even recent moves to have ecocide added as a new crime to the Rome Statute. But that's for another discussion. The last development I'll say is the use of technology, which fascinates me. The use or the existence of technology, smartphones, the internet, has really started to play a role in the commission of atrocity crimes. We're seeing perpetrators posting on Facebook, on TikTok, all over social media. They're using phones in the commissions of violations, which can be tracked using cell tower technology, satellite imagery. So as all of this technology comes into play with respect to the commission of violations, investigation teams are now looking at call data records, intercepts of mobile phone communication, satellite imagery, social media, hard drives, storage devices. And so it's quite overwhelming because that presents huge challenges. When I started off as a criminal barrister, I was always taught, you don't go to court until you've read every word of the evidence, which now makes me feel old because, that's no longer possible. I was talking to an investigator who's investigating the Islamic State at the moment, Daesh, and he said to me, the days of barristers being able to read all the evidence are finished, forget about it. He said, it's just not possible. So I often think about, my old mentors would be horrified. And just to give you an example, the IIIM that I mentioned investigating Syria has preserved in its central repository 138 terabytes of data made up of 434 collections from 146 sources and represents 3.75 million records, out of which it has processed 2.3 million records. And then they receive a request for assistance from German Prosecutor saying, could you provide us with anything relevant to these proceedings? The Myanmar mechanism that I mentioned has now got a repository of 3 million different information items in only the few years since it's been active. And so just to finish, the International Criminal Court and many of us are now having to look at, using technology to process all this evidence that we are gathering, like artificial intelligence, machine learning tools, translation platforms, so that a lot of this information can be processed before a human actually comes to review it. So the last thing I'll say then is with respect to the Commonwealth, some recommendations. Where violations have been committed inside Commonwealth states, obligations under international law to investigate, prosecute, provide remedies and reparations to victims need to be met. I think those countries that have not yet ratified the Rome Statute need to do so, and Commonwealth states need to encourage each other to ratify the Rome Statute. I think much more support needs to be given to the International Criminal Court and other accountability efforts through budgetary support, technical support, practical support, because they have these enormous tasks that I've just been describing and are often doing it with very few resources. I think when setting out policy agendas, avoid the two-tier structure of international justice, actual two-tiered justice and the perception of two-tiered justice. And lastly, to exercise universal or other extraterritorial jurisdiction where that's possible, and allow and pass laws allowing for its use in appropriate cases. So I'll end it there, Sue, but I'm happy to take a few questions in the 10 or so minutes we have remaining.
Thank you very much indeed, Kingsley, for laying out, as you say, that evolving ecosystem of international criminal justice. There are indeed three questions, first of which comes from William Horsley, who's International Director for the Centre of Freedom of Media at the University of Sheffield, referring to UNESCO. UNESCO's finding that the rate of impunity in Commonwealth countries around the cases of killing of journalists is as high as 96%. And that is significantly higher than the global average. You have emphasized very much trends in, well, if you might be termed high crimes and misdemeanors, I mean, the appalling levels of human rights abuses. Obviously, these are violations of human rights abuses perpetrated by states and not pursued by states. So what do you think the causes are of the failure of states to address this? Is it legacy of draconian colonial era laws? Is it systemic failures? Is it lack of institutional mechanisms? What's your view?
I'm just skimming that question by William, which is a great question. And, I think that there is, without question, in many countries which, were former colonies, the legacy of colonial era laws, which remain problematic into the modern age in Southeast Asia, in South Asia, and other parts of the world, laws that should have been repealed long ago. And I'm here thinking about laws of sedition, blasphemy is another one. These kinds of laws are still being misused and weaponized, in fact, by states to retaliate against human rights defenders, political opposition, and particularly journalists. And what's so insidious about that when it happens is that it's often done under the guise of, or the excuse of, it's the rule of law in operation. We have these laws on our books. These people have violated these laws, whether they be a journalist or whether they be an opposition politician. And it is inappropriate for us to intervene. We have a court process. They will appear before an independent judiciary and they have their remedies in the court system. They have the right of appeal and so on. And the use of those laws, in many cases, the fact that they have not yet been repealed, or the fact that they are still being used in individual cases is highly problematic, and something that I've worked on quite a lot in the last several years, because it's the very opposite of the rule of law. The rule of law isn't just passing bad laws or keeping on your books bad laws and then misusing them, saying that this is a process that we shouldn't interfere in. It's about adhering to your international human rights obligations, protection of freedom of expression, freedom of speech, freedom of association, and many other freedoms that people have under international human rights law that is binding on those same states. It's also complex because those challenges often exist within a more complex context, because you also have usually at the same time the politicization of the court processes, the lack of an independent judiciary. You often have corruption, political interference and politicized cases, sometimes investigators without capacity. So there's a lot of judicial sector or legal sector reform that needs to take place in many of those situations. But certainly the legacy of a lot of colonial era laws is part of the problem in many cases.
Thank you, Kingsley. Another question from William Crawley, who is a senior research fellow here at the Institute. In your view, how much have national right to information laws contributed to the ability to pursue accountability at a domestic level? Do you think they've strengthened the hand of INGOs in investigating international crimes?
Yes, the answer is yes. And that's another example of some of the sort of legal innovation and strategic thinking that's taking place around the world, where victims and civil society organizations are not just looking at what can we achieve directly through criminal proceedings at the International Criminal Court or in the tribunals. You know, what can we actually achieve also through civil proceedings, going after corporations, but also right to information laws. And there are examples of that in different states where that request for information from states has resulted in bolstering some of the cases and some of the repositories of evidence or the documentation that civil society organizations are doing. So often when we sit down with civil society organizations and victims groups, you know, we look at strategic litigation, you know, what are we missing, what do we need, and what possible approaches could we take? And, you know, Information Act or National Right to Information Laws requests is sometimes one of the avenues worth pursuing.
Thank you very much. Two questions connected to the ICC and ICJ, one of which is, should we anticipate the indictment of Bashar al-Assad by the ICC, in your view? And secondly, it's a question for the ICJ, why doesn't the ICJ use local and indigenous people to investigate crimes against humanity rather than depend on professionals which might not have as detailed which might not go as deeply into the actual cases?
Yeah, so we the ICJ, if that's who you're referring to, are not investigating crimes against humanity. You know, we are actually mostly supporting, you know, local groups, civil society organizations, national groups in their work. And in fact, it's probably one of the most important elements for a successful investigation and prosecution, which is to bring those groups within a country who are victims groups or victims representatives or civil society organizations together to consult with them as to whether or not they want to contribute towards the various accountability processes being described. And if they do, you know, how can that be achieved in a way that is not just an extractive process where we say, or not we, but the accountability body doesn't say, look, we've arrived, we're the latest people on the scene here, we know you've been working on this for the last 30 years, but could you just give us everything you've got? That model, although it has happened sometimes in the past, is considered to be appalling and unhelpful these days. And some of the work that's being done by the ICC, the IIM for Myanmar, the IIIM for Syria, is actually focused very much on ensuring that this is a two-way relationship, that civil society groups who know the context, know the language, often are sitting on mountains of information, are brought into it in a meaningful and respectful way, and it's not an extractive relationship. And in fact, some of those mandates have gone so far as to enter into individual memorandums of understanding with the different groups to ensure that that relationship is preserved and guaranteed in a way that's not extractive. So there is a real, I can say with confidence, there is a real move these days to ensure the kind of concern that you're raising is something that is addressed in a meaningful way, and that we're not having international criminal lawyers parachuting into complex situations and telling everyone to step aside. And certainly Seizure, the organization I was talking about before, actually a lot of the investigative work they did in Syria was by training and working alongside, national activists and investigators in a collaborative way.
Thank you. And the question about Bashar al-Assad being prosecuted. Is this? I'm not aware of this, but are there processes precisely to bring?
One of the big challenges that the ICC faces, and many of these mechanisms, is that they don't have their own police forces. They don't have their own ways of implementing, an arrest warrant that is issued, and they rely very heavily on state cooperation. And so when the ICC issues an arrest warrant and seeks that a state bring the person before the court, it sometimes happens and it sometimes doesn't happen. And it is a hugely politicized process. And part of one of the criticisms that these processes receive, which is, is the ICC a court without teeth? Is it ineffective? Is the money worth it? Why are some states cooperating? Why are some states not cooperating? There are also then issues that I don't want to get into in this talk around immunities for head of state and so on. So the answer is, it's a complexity. I can't say whether or not I'm anticipating an indictment or not an indictment or an arrest, but certainly that is one of the challenges. And I often think that the criticism that the ICC and many of these processes face for not being able to directly go and arrest people and bring them in once warrants have been issued is actually a criticism that's better leveled at states, because these processes and the International Criminal Court in particular are really only as strong as the support that they get from states and the cooperation that they get from states.
Thank you. I've got time for two more questions, both of which concern processes. First of which from Dr. Nicholas Watts, Senior Research Fellow at the Institute. Can you say anything about lessons for international government organizations working to achieve agreement in defining and prosecuting ecocide? And secondly, from Dr. Mark Simpson, Visiting Fellow here, do you have a view on truth and reconciliation models versus international criminal justice?
Sure. I'll say something further about al-Assad. I also don't want to say I don't know whether he will be ever indicted and arrested or not, full stop, because I can go further than that and say, not only is it always challenging because of the reasons I described, but it's going to be particularly challenging in that case. And that's why we often talk to victims and say, well, same as the victims in Myanmar, asking whether or not the military leadership in Myanmar is ever going to be arrested and indicted and brought before the International Criminal Court. The answer is it's going to be very difficult, because it's going to rely them on traveling to states where that state has the political will to arrest them once they're in the territory and present them before the ICC. And it may take many, many years. So I tell affected communities, be hopeful, but also be realistic with your expectations. But it does happen. And I often think of the example in Cambodia. When I joined the Khmer Rouge Tribunal in 2006, they just arrested some of the senior leaders of the Khmer Rouge and brought them before the court for crimes that they committed in the 1970s, some 25, 30 years earlier, because the political winds and the political situation had changed. So do I think that there will ever be an indictment or he'll ever be arrested? I'm hopeful, but I don't know. It's a long and complex, challenging process.
Thank you. The question about lessons for NGOs working to achieve agreement for defining and prosecuting ecocide, and a view on truth and reconciliation models versus international criminal justice. Do you have any? I don't
have a lot to say on ecocide, because I haven't worked on it very, very much myself. I have, if Nicholas, you are particularly interested in this question, I have friends and colleagues who are working very closely on this issue, and I'd be delighted to connect you. It's again another very challenging initiative to gather together the political will to amend the ICC's Rome Statute to add the crime of ecocide alongside genocide and so on. But I'd happily refer you to them. The truth and reconciliation models versus international criminal justice. Yes, I mean, truth and reconciliation models and often come under the sphere of what's called transitional justice are incredibly important. Transitional justice looks at there being several pillars to it when countries are transitioning out of, say, conflict. And it's not just about prosecutions, it's also about other things like truth-telling and reparations for victims and legislative reform. And these all have their place, absolutely. And there have been good examples of truth and reconciliation models around the world. So it's not really a choice of choosing between one or the other and which one's best, which one's not. Truth and reconciliation models often happen within the framework of transitional justice, and that is also something which supports prosecutions. What is certainly not the case, that it is never a substitute for investigations and prosecutions. It's sometimes proposed, oh, well, maybe it's too difficult, too complex, the situation's too sensitive for us to carry out investigations and prosecutions. We should maybe rather instead hold a Truth and Reconciliation Commission. That is not something that is accepted under international law and standards as being the way forward. And there have been, various principles produced which have been, accepted by states, including the principles against impunity, which say that prosecutions and investigations still need to take place. The problem with truth and reconciliation models is that you really have to have the right environment, because one can imagine certain situations where it is just not likely that you can have a situation where both victims and perpetrators and members of the state apparatus and maybe members of the military come together and tell the truth about violations, and there's a healing process. That is possible and has been successful in certain instances, but other instances or other situations, we're just not there yet and may never be there for that to be a meaningful process. So it's not a one or the other thing. Both have their place where they are possible.
Thank you, Kingsley. I'm going to squeeze in one more question, if I may, and thank you for your time. In your opinion, what are the chances of seeking justice under the Alien Tort Claims Act for the Rohingya people? And squeezing in a second question, what are the main benchmarks for a criminal complaint under universal jurisdiction by fortified rights in Germany? You may or may not be able to answer those questions. But,
the first one, the Alien Tort Claims Act. Yeah, I'm not the right person to ask about that. That's also something very specific that I've not looked into in any detail. The second one, though, I know Fortify Rights quite well and the excellent work that they do. I'm aware of the criminal complaint that they've filed in Germany under universal jurisdiction. But I'm not sure what you mean by what are the main benchmarks for the criminal complaint. How will we measure its success, or what do I think the prospects of success are? I mean, all I can say really is that, certainly it is it's another advance. It's another avenue for accountability that's been opened up for the Rohingya people, which is a good thing. The other positive feature of it is that Germany has a very now reasonably experienced war crimes unit filled with specialists who have now carried out universal jurisdiction type cases previously, prosecutions of crimes that have committed in other countries. So there's a degree of experience and capacity there in Germany, which I think is likely to help that process along. But again, it's going to be enormously challenging, not only to gather the evidence, to bring together an investigation and issue an arrest warrant and a potential trial. But again, like all of those things I've been talking about, including Assad, the prospects of actually finding a perpetrator in a jurisdiction where it's possible to execute the arrest warrant and deliver them to Germany for them to actually stand up in court. Many of the cases that we've seen with regards to Syria and some of the African states in Europe, which has been the majority of universal jurisdiction cases more recently, has been because the concerned persons are dual nationals or living in Europe in some capacity.
Thank you very much. Colleagues and Kingsley, I'm going to draw this fascinating lecture to a close. Kingsley, our sincere thanks to you for giving us such an eloquent presentation on accountability trends and for emphasizing the increasing sophistication of CSOs and recognition of their work and the importance of their work. But also for your realistic appreciation of the enduring difficulties and this question of political will. But this is clearly work which will continue at multiple levels. And it will, as you have underlined again and again, that it may take decades, but that still does not mean that that effort should not be put into this. We look forward to welcoming you at the Institute, and thank you very much indeed.